Okay, good morning. Let's get started. A lot to cover today. First of all, the National Weather Service has issued a warning for a winter storm warning for New York City. We may not have class tomorrow. Yay. Still got to cover the materials, so I don't know. I always hated makeup classes, so yeah. Okay, so 6 to 12 inches. We'll see. I'm going to follow both the law school, obviously if the law school shuts down, if they cancel classes, we're not having class. But I live in New Jersey, so chances are good. Okay. What else? What other administrative matters? One comment on class recording. I'm probably going to change the policy next year, so too bad for you. But no, you keep emailing me with all kinds of new hypotheticals, like I had a planned interview that got moved and unexpected. And so the rule for this year, just to be fair, is just it's unexpected, unscheduled conflict. If you schedule a meeting during class time, no matter how important it is to your career, like you have a monthly meeting at some, important organization that you've decided to go to, knowing that you had this class, I'm not going to give you the recording, at least not this year. Yes?
Are the classes already recorded?
Yes, classes are always recorded. I'll send you a link. Yes.
Then, if after classes are done, you just make them widely available.
Yes. Yes. So about maybe even like 2 weeks before, I'll just give you all the links for like exam prep. Okay. But I'm just trying to give you an incentive to be in this room. But I'm debating. It seems too paternalistic, so I think maybe next year you're on your own. Okay. What else? Okay, so what are we going to do today? Where's Ben? Hey, Ben. Okay, so Ben organized a protest. How many in favor of postponing the practice exam review until after spring break? Look at that. Well done, Ben. Well done. All right, so it shall be. So you all seem really stressed right now. I get that. It's an exhausting time of the semester. I have, 2 symposium papers to write, slides. So it's a busy time. Okay. So what we'll do today is just discuss, we're going to try to rocket our way through the remaining What is a Securities material. Apologies to those of you who would rather spend more time on this. You certainly can. But these are pretty cut and dried special settings, with the exception of the Reeves or Reves. Does anyone know if it's Reeves or Reves? Reeves? No, that would be 2 E's. Reves? What should we say? Reves? Okay. So what is a note we'll spend a little bit more time on because there's actually a legal test. But otherwise, we'll go pretty quickly through this material. Tomorrow or probably Thursday, we'll start the exemption material, which we probably won't finish if there's a snow day this week until after spring break. So after spring break, we'll do the practice exam and begin insider trading. All right, any administrative questions? All right, so let's rocket our way through. Foreman, this is just going to be pure lecture, okay? This was me sitting at S&C training, first year associate training. Here we go. Foreman. So Foreman, economic realities test. So Foreman involves this co-op city. So a cooperative, what is a housing cooperative? For $200, a housing cooperative is a legal entity that owns title, right, to the real estate and issues shares. Okay, I hope everyone understood that from the little blurb. So the shares that a cooperative issues entitle you to something like a possession. Well, they definitely entitle you to possession. They entitle you to something almost like ownership because in fact these are shares. They are like shares of stock. They can be sold. They are property. Except that shares of a cooperative, right, have this kind of weird property about them that they are, in fact, shares of stock, but shares of stock of a company whose sole purpose is to own real estate in which you will live, right? So not all shares of companies that own real estate are covered by foreman. But in the case of a cooperative, and we have some facts here that sort of make this clear, the sole purpose on page 285 of the casebook of acquiring these shares is to enable the purchaser to occupy an apartment. In effect, their purchase is a recoverable deposit on an apartment. The shares that they buy are explicitly tied to the apartment. They cannot be transferred to a non-tenant. They can be pledged nor can they be pledged or encumbered, and they descend along with the apartment only to a surviving spouse. No voting rights attached to the shares. Participation in the affairs of the cooperative appertains to the apartment, is attached to living in the apartment, with the residents of each apartment being entitled to one vote, irrespective of the number of shares owned. Okay, so also there's this right of redemption to River Bay. This is really not a set of facts that you need to worry about too much because the SEC has issued guidance, you saw, on real estate condominiums and real estate interest. But just see how the Howey test is applied to these, say that differently, how Section 2A1 is applied to these shares of stock. The issue here is that the shares of stock are stock. And so by Section 2A1, by the terms of 2A1, the term security means any stock. And of course, as you read, the court nonetheless turns to Howey, which is kind of an interesting move because Howey concerned investment contracts, which show up somewhere else. Where do they show up? Any put, call, option, and privilege, or any interest, instrument. Where is invest? Oh, there it is. Sorry, it's early. Okay. Transferable share investment contract. So investment contract is disjunctive, right, with stock, meaning you should normally construe the statute as defining the term security as including stock. And you don't ask whether stock is an investment contract. But in a judicial jujitsu move, they say we adhere to a basic principle. You always have those basic principles you can pull out that has guided all of the court's decisions. In search for the meaning and scope of the word security, we should disregard form for substance, and the emphasis should be on economic reality. In other words, the statute does not say what you think it says because the economic reality of a share of a cooperative is not like the economic reality of an investment contract. It's kind of one way to think about this, right? In fact, there's then this sort of repeated reference throughout the opinion to the Howey case, as if we're not viewing share and investment contract as disjunctive alternatives, but rather sort of we're supposed to read the reference to stock as, stock, we're not reading stock and investment contract as disjunctive alternatives, but rather we're supposed to read stock in light of the reference to investment contract. An approach that is not taken, by the way, with respect to note, as you've read. So this is incredibly sort of confusing and convoluted, but this is what they're doing. And so the claim, the conclusion is that, in fact, the economic realities transform the share of a cooperative into something not security-like, not investment-like. In fact, it's like consumption. And in 289, in the casebook, in the present case, there can be no doubt that investors were attracted solely by the prospect of acquiring a place to live and not by financial returns on their investments. What distinguishes, reading a little bit further down, a security transaction and what is absent here is an investment. where one parts with his money in the hope of receiving profits from the efforts of others, and not where he purchases a commodity for personal consumption or living quarters for personal use. Okay, so consumption is not a security. That's the rule. Now, notice there's something happening here that we're going to see happen over and over again, which is that we're trying to define, we're told that the economic reality test is supposed to look to whether or not the stock is an investment. But then, a very helpful circularity in our analysis is to point out that, in fact, there is no investment where one parts with their money in hope of receiving a profit from the effort of others. In other words, if you see nod your heads if you see the circularity. We're going to say, look, whether or not a share of stock is in security depends on whether it is similar to or has the same economic reality as an investment contract. And we're going to conclude that the shares here did not have that characteristic. Why is that? Because the purchasers did not seek to make an investment. And that's a little problematic because whatever expectation the purchasers had is either one of two things. Either that's an empirical statement about the world, in which case there's no empirical evidence that these purchasers had no investment motive. Nobody asked them. Nobody conducted a survey. You should start to see, I like to think in this way because this is an empirical claim. I mean, literally, it's a claim about there can be no doubt that investors were attracted solely. How do you know? Because you've decided that there can be no doubt as the judge. You've talked to each one of them. The clerks have reached the view that there's no doubt that the purchasers of these cooperatives were not attracted by a financial return on an investment? Really? I mean, real estate appreciates in value. In New York, consumption real estate often has an investment value. I mean, how many people bought apartments in the 80s that they quadrupled 10 times in value today? So this test, you start to see how kind of vulnerable it is, right, to any critical thinking. Because when you can't really answer what an investment contract is other than by pointing to the investment motive, which isn't actually empirically based in anything, other than the judge's decision that this kind of contract has no investment motive and a consumption motive, well, all that's really happening is that the court is just deciding that they don't think, for whatever policy reasons in their heads they find convincing, that these particular contracts should be subject to securities laws. That's the point. The point is we're going to decide that it's not an investment because we've decided that we don't think it should be an investment. And that's what's happening here. It's just like other things we've seen, like the difference between the duty to update and the duty to correct. Is this clear? Does everyone see the circularity? There's no evidence whatsoever as to what purchasers thought when they bought cooperatives. It's a complete lie. There's no doubt. There is 100% doubt. There is no evidence about lack of doubt. Okay? Great. So, with the greatest of respect to the judiciary, that is just not true. There is no evidence whatsoever. There's a ton of doubt as to what cooperative purchasers thought. Okay, so that's the law. What happens in the International Brotherhood case? Well, we continue into the world of non-contributory compulsory pension plans. All right, what are these? Well, instead of having your paycheck deposited, something withdrawn from your paycheck or your employer matching contributions to a 401k, right? Back in the day, your employer would set up a pension. And the value of the pension, so you can think of it like I'm getting $10 an hour, and while I'm not withholding $1 to put in my 401k in this world, and my employer isn't actually matching my $1 contribution, the theory here is that the pension plan is a security nonetheless. Why? Well, because at least I exchanged something of value. What's the something? Well, if I didn't have the pension plan, notice it's compulsory, so it's a little problematic, but if I could have chosen not to have opted in, then I would have been making $11 because my employer would be able to discount the future obligation that it had, right? And so thereby increase my salary today, or even in the future, doesn't really matter, And so this really was not a persuasive argument, right? As you saw in 292, only in the most abstract sense may it be said that an employee exchanges some portion of his labor in return for these possible benefits. That is, these possible pension benefits. So this sort of I'm not going to spend much more time on this. It falls on the exchange of money. It's really not that interesting. There are other problems as well. It does not seem that there's much of an expectation of profit from the efforts of others, and even the common enterprise is problematic. But just understand, if you're looking for an example of where there's no exchange for money, international brotherhood is one. Okay, what about condominiums? So page 295. Now the SEC in 1973 issues guidance as to condominiums. And the basic conclusion is that condominiums are generally not securities, right? Again, similar to Co-op City, the theory is this consumption theory. When you buy real estate, you have this consumption motive. Notice how, just as a tangent, how incredibly sort of conclusory this all is, because there's no even claim that, somehow this subjective intent of the purchaser matters. Like, nobody goes and says, well, maybe if you intend to buy a second home, then that's a security. Of course, that would seem very unworkable, but it would be much more consistent with the idea. If the idea is consumption versus investment, then why can't you, at least in an evidentiary sense, impose some burden of proof to show that you had a consumption motive, right? Notice there's no reference to any sort of evidentiary standard of proof of consumption, of a consumption motive. It's just we're going to read in to certain transactions a consumption motive, call them consumption, even though we kind of know that in many of those cases there's a tremendous investment motive. Yes?
So I agree with you that the motive is like interesting, especially when you divide it into things like buying stock in a co-op. But if you go down that road, then how can you ever draw a line between, like, you could buy a lot of vinyl records because you want to resell them, or like Pokemon cards, but you're not. Those are very consumption-oriented. You couldn't count like a Pokemon card as a security.
Joseph, right?
Yeah.
Gotcha already. Yeah, absolutely. Absolutely. So Joseph says, look, yeah, it makes maybe more sense to look to subjective motive, but it's like impossible to implement in practice. That's right. Which is why it's not done. But ask yourself if, as a first best, we can't practically look into the hearts and minds of the buyer and activate securities law in the case of investment motives. We can't really do that practically. We think that's hard. Why not approach the second best of some data as to what people's motives are? Now, if Pokemon cards are, well, might be a, so they might fall another, there's not a common enterprise necessarily, and the profits may not be from the efforts of others, so they might be a problematic example, but the real estate example is an easier one, right? Suppose you could bring data to show that in New York City, it turns out that when people buy condominiums, that 60% of buyers have an investment motive. Why is that irrelevant? Like, why should that be irrelevant? I mean, it certainly seems more relevant to me than just a decision that a particular kind of transaction doesn't. Now, to be fair, the SEC does sort of call out the rental pool. So what the SEC wants you to do is look at the characteristics of the transaction and say, okay, well, some transactions seem to evidence this investment purpose. But that is going to give rise to all kinds of lawyer games, right, and loopholes. Because you say, well, a particular transaction, everyone might realize that this is widely used for investment purposes, that this is all about speculation on the value of some underlying asset, like buying a condo, a simple example, buying a house. Like, everyone in this market clearly speculates, is doing that for speculative reasons, or 90% of them, okay? And in fact, the SEC is going to say, no, that's not a security unless certain characteristics of the transaction, like the rental pool example they give in the guidance, would indicate sort of on the face of the document that there's an investment motive. There's going to be a facial versus as-applied analysis, right? They're going to want to see a facial investment motive, but that is really easy to manipulate. And so when we get to the Bristol case, the Citicorp case, right, we see that exactly playing out. Because what's happening in Citicorp is they structure this incredibly complex securitized investment vehicle, which is ultimately a limited partnership legally, that issues securities. And the question in Citicorp is if you create this really complicated vehicle whose sole purpose is to securitize assets, is it in fact a security? And the court concludes, no, it's not a security. It's not a security because why? Why was Bristol not a security? Remembers? Sort of at the end, you can always kind of jump to the bottom line. Okay. So they changed. So the limited partnership agreement in the Citicorp case gave Steinhardt, the buyer essentially here, pervasive control over the management of the partnership. Indeed, these quite significant powers are far afield of the typical limited partnership agreement, where a limited partner leaves control of the business to the general partners. We find the agreement altogether consistent with the arrangement before us. Steinhardt, a sophisticated investor, made a $42 million capital contribution in Bristol Oaks, thereby becoming a 98.79% partner through a highly negotiated transaction. In other words, you can create the transaction in such a way, at least Citicorp seems to suggest, that you can evade being a security because you transfer control. Now, this isn't like directly on point to the real estate example, but it does kind of show this evolution of how the economic realities test kind of just blows up the definition of what is a security and allows for a lot of games. Okay, so here, if I structure the deal so that it effectively involves a sale of nearly 100% control, it turns out that it's not a security. Go figure, right? Even though, like, what is being sold are equity securities, like ownership, shares. Does everyone understand how this is playing out, okay? So you have this real estate example where it's kind of turning on this definition of consumption, which is itself incredibly fluid and flexible, right? You can stretch consumption. You're not actually looking to any empirical evidence as to what people think in terms of their motive. You're just going to read into certain kinds of deals a consumption or investment motive. You're going to say, well, some deals, like rental pools, have this investment motive, and so those, the SEC guidance tells us, those are going to be viewed as securities, potentially. And then you start thinking, well, maybe I can continue this logic, sort of saying, well, let me set up a transaction and structure the transaction so that it kind of involves a sale of control. And if it involves a sale of at least formal control in some structured entity, some special purpose entity, that will evade the securities laws because at the end of the day, it looks a lot more like a highly negotiated transaction. All of this is a highly arbitrary, sort of shifting the contours of a security. It goes back to our conversation last week that basically what the courts are trying to grapple and trying to wrap their hands around what should be under the purview of securities regulation. One problem I want to keep reminding you of is that the law itself, the statute itself, refers to investor protection. And in all of these convoluted conversations around like what is a security and these stretching the boundaries of each of these tests, there's very little reference in these opinions so far to the problem of paying too much for something. Right? And I want you to think about that as you're reading this. So sort of how would you approach this for an exam or whatever? Well, you need to understand these tests. So if you get a real estate, hypothetical, you need to be able to say, look, there's guidance on the condominium case, whatever. Maybe the shares would fall under the Foreman case, whatever, cash that out. But at the end of the day, you want to be thinking, right, is there a concern of overpayment here? And where is that concern coming from? And that doesn't happen in these cases, right? They are playing with some sort of almost, as I said, ontological kind of sense of what an investment is. But remember, in economics, investment, a security is just any contingent contract, a contract that pays off in some states of the world. So the courts are kind of unanchored from any economic theory in trying to wrap, like I said, their hands around what they think an investment should be. It's a normative judgment. That normative judgment is largely uninformed by any empirical evidence and largely reflects what feels, by and large, it seems, to the courts to constitute a security. Notice, never, in any of the cases we've seen so far, is there any evidence that people are overpaying or underpaying for what they're buying. There's no data on pricing. There's not even a story that I went out and bought something that was too expensive. Instead, most of this litigation is arising from fraud claims, and the goal is to sweep in the contract into 10b-5 so that you can federalize the fraud claim and gain the benefits of 10b-5, right? And so that's the posture in which this is arising. So in the language of investor protection or defining what is an investment, what we're really seeing is courts trying to decide whether a particular claim should be actionable under the securities laws. And they're not doing that, by and large, with any sort of consequential analysis, right? Like, what would the consequences be of embracing this interpretation, and particularly the consequence of investor protection, which is the one that we care about. Does everyone see this? Okay, I'm going quickly through these cases. Yes, Sasha. Good. Right. Good analysis. So Sachedal says, look, we talked about investor protection as the problem of overpayment and underpayment. And if you think that you're more or less likely to overpay for real estate because you are sort of swept up in kind of go back to our Vita, go back to our early stories of securities regulation as kind of putting the brakes on hype and enthusiasm and excitement over crypto. Look, this is the next crypto. You know, there's a long list of assets like these. Real estate falls clearly in that category because, you know, this is the place to buy a house. If you don't buy a condo in Brooklyn, you're going to miss out on the next wave, right? That is speculation. Now, the question is, if we think that in those cases there might be overpayment or underpayment, meaning I'm likely to buy a condo that is too expensive relative to its cash flow, relative to how much it's worth, then you want to say, okay, if we subjected that condo to the securities laws, if we said, look, to buy this condo, you need to file to sell this condo, you would need to file an S1, or you would need to, we need to come into a regulated transaction some other way, like a public reporting company who's filing 10Ks and so forth. If you said, look, by doing that, we would reduce underpayment and overpayment because we would be giving more data to potential purchasers. You then would want to think, okay, so is there a story whereby that protects investors? And Sachedal's point is to say, look, it could be that in good economic times and economic booms, investors are more likely to be swept up in real estate mania. And that's precisely the kind of intervention that we think the securities law is really good for, protecting investors from speculative risks that crash and blow up in a pro-cyclical way. That's what the law of investor protection is supposed to do. It's supposed to protect investors from investing in a way that blows up when they need their money. Does everyone see that? So I find that much more interesting, personally, than this kind of ontological question around whether, consumption is consumption enough versus investment versus, it's sort of a meaningless distinction in a way. I mean, it reflects something real, but it's extremely pliable. Okay, there's no sort of real guidance there, just arbitrary conclusory reasoning. Okay, other questions? Does everyone see that? So that's the kind of analysis I think would be really good on an exam, which is like, okay, here's a contract. It's not clear we could categorize it under these cases one way or the other, but let's think about investor protection. Keep that in mind. Someone pays a particular price. Are they overpaying? Are they underpaying? Why do we think disclosure or subjecting this contract to securities law would reduce that overpayment or underpayment risk, and is that likely to make them better off as pro-cyclical investors who are exposed to the macroeconomy? Okay, I've regurgitated it 5 times, making sure everyone gets it. Okay. So In the case of Steinhardt, in the case of Citicorp, the answer is no. It's not a security because there's a lot of control. Well, we're going to come back to control. It turns out that's not such a useful test. I would say in the case of limited partnerships interest, everybody understands what a limited partnership interest is? Yes? LP interests are like just shares of stock in many ways. They're designed for passive investors as distinguished from general partnership interests, right? Typical classical partnership agreement where you are agreeing to share the risks of the firm. What's the difference between a general partnership and a limited partnership interest? Well, it's just all about limited liability, which is all about investment, right? So in a way, you could say, so if I am, at least this would be the logic under kind of the Howey style reasoning, that if I am bearing the risk of loss, that probably means that I am involved. And this goes back to our conversation last week. Michael and I had this exchange as to whether that test makes a lot of sense. But the idea here is that if there's a partnership, it's like a franchise. It's like a joint effort where we're working together to shape the business. Our joint effort leads to the firm to be more profitable, and that joint effort sort of takes it out of the realm of passive investing, which seems to be the logic that's underlying Howey. So by and large, general partnerships are not securities. Most limited partnerships are. What about LLCs? Are LLC interest securities? Circuits split. It's a controversial question. LLCs are sort of your epitome of private ordering, right? They are, in fact, opted for by companies who want special treatment, sort of their own corporate law to govern. I mean, you can't completely get out of all duties of corporate law. There is a sense that LLCs give you a little bit more flexibility, and so they're preferred by people who like private ordering. If you like private ordering, if you like to choose your corporation menu of what goes into your corporation, then in fact, maybe that's a rationale for viewing LLCs as non-securities. Because if you participated in that kind of choose your own adventure, build your own corporation, build your own LLC, then maybe you really don't need the securities laws. Again, notice how sort of empty this all is. It's kind of like, well, I don't know, maybe average people do buy interests in LLCs. Who knows, right? A lot of this is sort of gut instincts that really aren't based on any empirical evidence whatsoever. Okay, Landreth, the return of formalism. So we got a lumber business that sells itself. All of its shares of stock is the sale of all of the company's shares of stock, the sale of a security. Well, it turns out that stock, equity stock, okay, of a firm, clearly not the sort of thing falling in Foreman. Clearly your typical, sort of quintessential definition of a security is equity stock. Classically, there was the sale of business doctrine, which largely gets rejected here, which held that, no, if you're selling your entire company, that is an M&A deal, right? And as an M&A deal, it is not sort of like passive investment, right? It sort of feels different. There's a lot of it's similar, it feels different, right? So the classical, it feels different. The feels different test led us to say, no. Typically, historically, the view was, in fact, no, if you're selling your business, you're probably selling it to a purchaser who can demand all kinds of information from you. You don't really need the 1933 Act to protect that transaction. Lo and behold, that logic does not convince the Supreme Court. And so, in fact, acknowledging that the cases have not been entirely clear on the proper method, this is on page 310, of analysis for determining when an instrument is a security. They must have taken this class to reach that conclusion. They then say, that actually our cases do not require us to look to the economic substance or the economic reality because, in fact, we would note on page 311, the Howey economic reality test, it's actually the Foreman economic reality test. Sort of Howey, which concerned investment contracts, was brought in to look at stock, which is, anyway, disjunctive in the statute, right? So this is like, yeah. We would note that the Howey economic reality test was designed to determine whether a particular instrument is an investment contract. Okay, that's fair. Not whether it fits into any of the examples listed in the statutory definition of a security. Moreover, applying the Howey test of traditional stock and all other types of instruments would make the Act's enumeration of many types of instruments superfluous. To be fair, the court does say in Part 4, we perceive strong policy reasons. There's some more honesty here about what's really going on for not employing the sale of business doctrine under the circumstances of these cases. And the issue that's identified here, okay, and this is an important one, is that, in fact, there is not a transfer of control, at least of 100% control, to the buyer. The court says here, Ivan Landreth apparently stayed on to manage the daily affairs of the business. And so there is a recognition that, in a way, you can buy a company, 100% of the company, and have the ability to exercise control, but nonetheless choose to remain passive, right, as to the day-to-day operations of that firm. And if you do that, you kind of look and feel, again, you feel like an investor. Okay, so that's the reasoning here. And there's this concern that if it were applied to this case, the sale of business doctrine, then we'd have to apply it to cases where less than 100% of a company is sold. Because after all, you can sell your company by selling less than 100% of the stock. Does everyone agree? How do you do that? Just sell a controlling block of shares, at which point you have control. Okay, and that's a weird outcome, right? Can you sell 35%? Suppose you have a dispersed firm where 65% of the stock is held by dispersed shareholders. If you sell 35, but there's a 35% block that you want to sell. I don't know, you're a block holder. You bought 35% on the open market. You want to sell it. If you were to sell it, would you be selling a security? Well, clearly something makes us want to say yes. I mean, you shouldn't be able to get out of securities law because you bought a controlling stake. I mean, where would you ever draw the line? 5%? 10%? 6%? 2%? So clearly, you would be. So if you would be, then we kind of like you to be subject to securities law if you're selling 100%. So if you buy 100% of the stock, equity stock of a corporation, is it a security? Yes. Under Landreth. If you buy 100% of the interest of an LLC, is it a security? No. No. Great Lakes v. Monsanto. If you buy 100% of the limited partnership interests of a limited partnership, probably a security, unless you also acquire control rights, and maybe you have to exercise them too. Go figure. Okay? This is the state of the law here. All right. Any more questions before we move to taking notes? No pun intended. All right. I told you this is like CLE. Here we go. Okay, taking notes. Revis. Reeves, I don't know. Revis. Let's look again here. First item number 1 on the list. The term security means any note. Any note. What's a note? Promise to pay a sum certain is a note. A note is a promise to pay. That's a note. When you take a mortgage, when you receive a mortgage loan, you give the lender a mortgage, and you also generally give the lender a note. You execute a note. In return, you get cash. The note is your promise to pay. The mortgage is your security interest. We all know this? Yes? Security interest is not the promise to pay. The promise to pay is the note. Okay. We're all on the same page. So, when you exchange cash for what? You receive cash and you give your lender a note in a security interest. Have you sold a security? Are you subject to Section 5 liability? Liability for violating Section 5 when you take out a home mortgage loan? No, you are definitely not. But it is not altogether clear why you are not until you start to really dig into this. Because, after all, you sold a note, right? You received cash and you gave a note. Okay. The performance of which, just apply Howey if you want to even think about it like that. There's a commonality in the enterprise. Your repayment, we did this last week, just to reiterate, your ability to repay the note, make your mortgage payments depends on your effort, not the bank's effort. So the bank bought something, right? It bought a stream of repayments that's dependent on your effort as the homeowner. And there's a clear vertical commonality. It succeeds only if you put in effort. Only if your fortunes and the bank's fortunes are intertwined. Is another way to think about it. So, that's a pretty straightforward analysis, right? The purchase of a note in exchange for cash should constitute a security if we applied Howey. But in rebus, definitely in the Supreme Court of the United States, that was for Amy. We reject the approach on page 316. We reject the approaches of those courts that have applied the Howey test to notes. Howey provides a mechanism for determining whether an instrument is an investment contract. The demand notes here, these were demand notes. Don't worry about that. There's not enough time. The demand notes here may well not be investment contracts. But that does not mean that they are not notes. So voila, it actually turns out that we're going to reread this as disjunctive, meaning you can be either a note or an investment contract. We thought you could be either a security, either stock or an investment contract, until Foreman told us, no, actually you're not stock if you're stock without, okay. But no, in the case of notes, we're now going to say that you could be a note or an investment contract. So, the court points out that, in fact, there is a test that the Second Circuit has articulated. It's called the family resemblance test. The family resemblance test, the Second Circuit's family resemblance test, begins with a presumption that any note with a term of more than 9 months is a security. Okay, so your mortgage is a 30-year note. You have a 30-year note, 30-year mortgage. So that should be a security under the family resemblance test, at least point 1. However, not all notes are securities. Okay, sorry, not all notes are securities. The Second Circuit has helpfully recognized that not all notes are securities. The Second Circuit is giving the test for deciding whether a note is a security and recognizing that for some reason we've decided, again, circularly, that certain notes are not securities. Well, it turns out it's not completely circular. It's actually based on history. There's a list. There's a list. The list tells you which notes are themselves. So on page 317, in an attempt to give more content to that dividing line, the Second Circuit has identified a list of instruments, commonly denominated notes, that nonetheless fall without the security category. This is from Exchange National Bank. These include the notes delivered in consumer financing, the notes secured by a mortgage on a home, the short-term note secured by a lien to a small business, the note evidencing a character loan to a bank customer, short-term notes secured by an assignment of accounts receivable, or a note which simply formalizes an open account debt incurred in the ordinary course of business. Notes evidencing chemical bank loans by commercial banks for current operations. We agree, the Supreme Court concludes, that the items identified by the Second Circuit are not properly viewed as securities. But more guidance is needed, right? Because after all, this is just a list. So, What are the 4 categories? I've been talking a lot. Someone talk. What are the 4 tests? The 4 tests in Rebus. What are the four requirements that you look at? The 4 elements. Someone talk. Yes, Mariah, thank you. Great. Yep. Great. Oh, that's a good one. We'll come back to that one. Okay, keep going. Great. So let's start with the third prong, my favorite. So Monday, I tell you that mortgage notes are not securities. Tuesday, what's your reasonable expectation about whether a mortgage note is a security? They're not securities. Wednesday, I tell you that mortgage notes are securities. Thursday, what's your reasonable expectation as to whether mortgage notes are securities? Now you have to reasonably expect that they are, because so this is a great one. Okay, expectations are endogenous. They are dependent on the law. And this is deciding what the law is. So, people should reasonably expect that whatever the Supreme Court decides a security is a security. So the Supreme Court's very helpful guidance is that we should look to their reasonable expectations. And thus, the circularity continues ad infinitum. It just goes forever on prong 3. Everyone see that? This is a common, reasonable critique of the reasonableness criteria. At the end of the day, we're trying to decide what's reasonable. And thus, reference to reasonable expectations or reasonableness in general, if you think about it that way too, is not very helpful. Okay. What about prongs 1 and 2? Motivations. We talked a little bit about motivations. Joseph and I, our conversation about Pokemon cards. So maybe motivations have sort of made their way back in. Okay. So notice that motivations, kind of in a little sneaky way, that's what my daughter likes to say, sneak it in there. So motivations kind of sneak in there this little circularity again. Because you're going to choose an instrument taking into account how that instrument will be legally characterized, right? I will choose a note of a particular kind, factoring in the costs and benefits of doing so. One of those costs and benefits is, in fact, its characterization or treatment as a security, or not. So the purpose, right, of a note or an instrument of any kind is itself going to emerge by reference to sort of taking into consideration how it will be treated. So the purpose test as a sort of theoretical matter is a little problematic. Now, you could, and as I said earlier, kind of empirically try to say, well, as of any moment in time, you could go out and poll and conduct a survey and say, what did you think the purpose of this transaction was? Well, the purpose of this note was to fund my business, my commercial activities of my business, and not investment. Maybe. This is like the Pokemon problem. Maybe. But of course, if people know that Pokemon trading will be characterized as a security, they might switch out of Pokemon trading and do something else to avoid being swept into securities law. All right? So remember, there's always a sort of endogeneity or a kind of dependence in any of these tests that turn on people's view as to the characterization of the instrument. Plan of distribution, all right, that's kind of vague. I think the more persuasive element here is the fourth one, which is the existence of another regulatory scheme that significantly reduces the risk. All right. Why is that interesting? Well, that starts to take us closer to the purpose of the securities laws. The purpose of the securities laws is to reduce overpayment. So this prong, unlike the others, actually has some content that we can work with. Means you would ask, is there in fact some other basis for reducing overpayment risk? Well, in the case of banking, you can make a pretty clear argument for why that answer is yes. There is an entire bank regulatory scheme, the purpose of which is to reduce risk in the banking sector. Now, does that mean, sort of applying that test, that a mortgage made by a bank should be treated differently than a mortgage made by a non-bank, not subject to banking regulation? So one challenge with the existence of another regulatory scheme is that the existence of those schemes itself tends to be somewhat arbitrary. It allows for creative lawyering to kind of take your way out of each of them. But it does, I think, take us a little bit closer to investor protection. Because at the end of the day, if borrowers are protected in some other way, banks, who are the investors here, are protected in some other way, we probably don't need securities law. All right, does everyone understand how the Reves test works? And there's a nice application here to these demand notes. At the end of the day, the court concludes that the demand notes are, in fact, notes under this Reves test. Questions? Does everyone see this? Is this clear? Yes, Davia.
I'm so sorry to ask you to repeat, but like, I'm not really seeing the point when you're saying about like another regulatory regime exists. Like, I don't know, could you just kind of go over that?
What would another regulatory? So sure.
Yeah,
so you go and get a home mortgage, and remember the Second Circuit had this list, right? The Second Circuit's list included home mortgages, but there was a sense that look, that's not enough. So we need to look when we look at a new note. We need to say, well, we can't just ask if it falls in the list or not, because you can change one thing and it's out of the list, and that's a problem. So we're going to ask if it bears a resemblance, a family resemblance, to the list. But we're not just going to like look for, I don't know, those are printed on white paper and this one's printed on white paper. We're going to look for criteria that make sense to compare the family on. It's like hair color, eye color. Like, in those ways, do you resemble your family members? Not like accent or something. I mean, like it's a okay. So, what are the four prongs of the family resemblance test? The four sort of categories we're going to look at. And the fourth one is the presence of another regulatory scheme. So the idea would be, mortgage loans have an entire regulatory scheme under the banking laws. So maybe we don't need to regulate the sale of a note in the form of a home mortgage under the Securities Act, right? So in another setting, you would try to look for some other regulatory regime and say, does that regulatory regime govern the note at issue? Okay, notice, note can be basically any debt obligation, just to make this point clear. It doesn't have to have, like if you've ever seen a note, they look like Old English. It doesn't have to have a seal or a, sort of special signature, right? Or like a feather or something. It just has to be a debt contract. All right, does everyone get this? Does everyone get this? Yes, Michael. Yeah, what's up?
Going back to the motivations of the buyer and seller, isn't it always the case that one of the buyers will be consumption-related and one of the purposes of the sellers will be investment-related? Or maybe the other way around, because a bank is investing in a mortgage as an investment.
Yes.
While the buyer is doing it for consumption.
Great. So, I guess this is all kind of half made up, but whatever. I guess you can say, okay, if one of them has a consumption motive, they both want to eat the proceeds. One wants to eat the house. I mean, what if But
doesn't a company also have a consumption? When they issue shares, they're issuing equity for their own investment.
Well, there I might say, Depends, right? So again, yes, you're right. This is very flexible, these definitions, right? But you could say, well, no, the company, it's, they're going to redistribute to shareholders. The shareholders are holding primarily, if you think of institutional investors, for capital appreciation. They'll consume in 50 years, but not today. So the primary purpose today of the equity investment is investment, not consumption. Like, that would be a very black letters or traditional response. I'm not saying it's...
Isn't the company consuming today? That's what I meant.
And a typical project finance, I have a project that costs me $100. I'm going to raise $100 from my investors. I'm going to put that capital to productive use. It's going to return $200, and I'm going to hand them back their $100 with a return. The employees of the company might consume their salary, but that's not generally, they're not consuming the investor's capital, right? The investor's capital is supposed to earn a return, and along the way there'll be consumption, right? But that would be the classical distinction. Notice the real estate example just kind of falls apart, right? How many people buy real estate for investment purposes? It just doesn't, so yeah.
I mean, but in reality, one of the reasons that people purchase rather than rent forever is to build equity. So kind of everybody's investing.
Yeah. Well, right. Except that the speculative real estate investor, takes zero consumption out of the house. So they don't live in the house for a moment. They don't step outside and savor the views, and right. They're never there. They don't care. So there's zero consumption. So you can easily find examples of non-securities that involve zero consumption. Like a lot of mortgage notes, a lot of them have nothing to do with consumption. There's just no consumption. But you're right. All consumption often involves not all. Okay, you could take your weekly paycheck and consume it and never invest. But a lot of it in consumption tends to involve some investment. But it doesn't go the other way around, which is to say you can find plenty of cases where the investment story, the consumption story, can be retold as one of pure investment very easily. And so if consumption is enough to move you out of securities land, then that is not a very compelling theory when you look at all these cases like mortgage notes, in which there's clearly an investment rationale a large majority of the time, large portion of the time. Okay, so my point isn't to say that it doesn't work some of the time. It just doesn't work always, and it doesn't even work probably most of the time, and it's for that reason unsatisfying. Right? Okay, does everyone see that? Now, sure, maybe consumption does explain the treatment of commodities. Where's Alistair? There you are. You sat over there in the other room. That's what. Okay. So the baseball, right? So the baseball story. Okay. So the baseball, or Pokemon. So you can pick commodities and you can say, well, these commodities primarily involve consumption. Again, not clear that they do. Maybe you're buying and trading in collectibles because you're a trader. Still, your collectibles are not going to be treated as securities under the Howey test or any other test, right? So it's both under-inclusive, over-inclusive, and thus crap. Okay, what else? All right, so special debt obligations. Other questions on Revis? But this is the law, so you need to know it. Okay. All right. Again, think about investor protection. Okay, who's being protected and why? All right. So the casebook talks about special debt obligations. You didn't believe we would get through this today, but here we go. All right. So commercial paper. Commercial paper, that's a good one. Does everyone know what commercial paper is? So basically, you're a business. Today, you need to spend $10 million on inventory. Tomorrow, you're going to sell that inventory for $11 million. The problem is, you need $10 million, and you need it today. Where do you get it? Well, you can issue this thing called commercial paper. And it's kind of like a short-term loan, where basically you borrow, but you borrow by going out to the market and saying, who will buy my commercial paper from me? I will pay you back very soon, in 3 days, in 7 days, I don't know, 1 day. And in fact, you get a loan, a very short-term loan, from the capital markets, in a sense. In a sense, because these are not your average buyers here, are not your average, Arvida Floridians. So Arvida also in Florida, right? All these cases come out. Yeah, so these were not your Orange Grove buyers, but in Howey. But these are in fact sort of this is the domain of investment banking, you could say, or the sort of line between investment and commercial banking. And so the question is that a note that is a security under Revis? And it turns out that, in fact, this one is very, very tricky. Because the SEC has long taken the position that the language in Section 3A10, so we're going to do exemptions either tomorrow or Thursday, and maybe we'll look at this, maybe not. But there is an exemption for commercial paper under the 1933 Act. Question, in the 1934 Act refers to short-term notes, but not commercial paper. The SEC has long taken the position that the language in the 34 Act applies only to investment-grade commercial paper. What's investment-grade commercial paper? But now that's an open question. You can see how you can kind of play with these definitions. Imagine what I think you should be prepared for is a lesson, for at least the exam, lesson in encyclopedic knowledge of all of this, which I wouldn't be able to do myself, but more a sense for if I gave you a new contract, okay? This is highly likely to appear. I might give you a contract where the contract has characteristics of debt. And what I want to see is if you know how to apply the Revis test and think about each prong and how it plays out in a contract of a new kind. Okay, that's much more interesting than statutory construction debates over commercial paper, right? I want you to think about, really what I think great securities lawyers are good at is thinking about new financing transactions and whether those financing transactions can be plausibly excluded from the definition of a security is of tremendous importance. And of course, the persuasive argument here is going to be tied to investor protection because that is the policy goal of the securities laws. Okay, CDs, certificates of deposit, classical holding in marine bank, certificates of deposit are not securities. And again, the reference is to the comprehensive set of regulations governing the banking industry. Okay. The purchaser of a certificate of deposit is virtually guaranteed payment in full. The holder of a long-term debt obligation assumes the risk of the borrower's insolvency. Perhaps then certificates of deposit are a special case because of FDIC insurance. It's not clear to me why. In the case of a bank failure that is not insured, you are guaranteed payment in full. You are a creditor, an unsecured creditor of the bank. So if you have a business account in excess of, and you deposit your money in exchange for a certificate of deposit, and you are above the FDIC insurance threshold, why is that virtually guaranteed? Why are you virtually guaranteed payment in full? Does someone disagree that you might be subject to some insolvency risk? It's called the bank collapses and you are not first in line. Does anyone disagree? I mean, is bank debt in general, even certain forms of depository obligations, risk-free? No, of course not. It's probably not very risky, probably doesn't happen very often, and thus it doesn't earn much of a rate of return above the risk-free rate. It's very low because there's very little risk, but it's not zero. It's not a treasury bill. Okay, so there's some confusion there. All right. Risk reduction. How far does it extend? So one thought here that the casebook brings up is collateral. So what if, an alternative regulatory regime is clear. What about collateral? What about secured debt? Secured debt. So secured debt is debt that is backed by collateral. So if you don't pay your mortgage, the bank takes the house. The bank doesn't wait in line with your other bankruptcy creditors. The bank gets 100% of the house. Or there's a priority question there, but okay, let's say, simplistically, the bank gets 100%. So my question is, why is that not a risk reduction device? And it's, in fact, interesting. In Bass v. Janney, Montgomery Scott, Inc., the Sixth Circuit found that notes should not be deemed securities when they were secured by assets of the borrower and stock in a subsidiary of the borrower. Think about that. All right, think about that. The D.C. Circuit was not persuaded that contractual provisions sufficiently reduced risk. I like this sort of line, even though it doesn't get a lot of attention by our beloved courts, but it really does kind of make sense. You could structure a contract. I mean, suppose, here's a hypothetical, suppose you buy equity, and I sell you with, I'm selling you stock. You buy equity from me. Clearly a security. All right, let's make it harder. It's the stock of a limited partnership. I don't know. It's limited partnership interest. I sell you a limited partnership interest, and in our contract, I insure you against bad states of the world. So I promise that if the value of the stock declines below a certain amount, I will make you whole. If I give you implicit insurance in the deal, sort of maybe bound your risk in some way. Or you could think of an even more complicated, fun, sort of creative mechanism whereby your effective risk is quite low. Is that a security? Well, that's a fun one. Because if you think about the formalistic tests, I don't know, probably your intuition would be to say if it's a passive investment, it's stock, there's no reason to take it out of the definition. Maybe you'd look at the control issue, maybe you wouldn't. At the end of the day, you come around and say, yeah, it's probably a security. But then you have to think about this intuition of risk reduction. Now, technically, this is it's not a debt instrument. All right, let's make it a debt contract. All right, let's make it a Revis-style note. And we get closer to Revis land, so I'll make it a note. And I'll include some kind of insurance against non-payment. Same thing. Insurance against non-payment, does that reduce risk? It certainly will reduce risk, right? So think more broadly about that risk reduction idea, because that starts to sound like something meaningful, right? That if at the end of the day, it's not as risky, maybe we don't need securities regulation, or not as much. Or maybe it's not a security if the other factors tilt that way. Does everyone understand how this thinking goes? Okay? Now go back to portfolio theory that we discussed in the beginning. Why did we spend so much time on that? Well, think about the idea of cyclicality. So suppose the investment risk has what we call in finance a zero beta. What does that mean? It means that it does neither better nor poorly when the macroeconomy is doing better or poorly. It has no link to the macroeconomy. Macroeconomy could be hot, and the securities payoffs, the risk of that security is the same. Like, maybe it's going to do well, maybe it's going to do bad, but those chances are no different when times are good, and they're no different when times are bad. And so that security we say is zero beta, meaning it has zero correlation with the macroeconomy. So that's a kind of risk-free security in a way. It's sort of risk-free. And you might think, this is an advanced point, you might think about whether for any particular investor they would be protected by buying a security like that. That's like a Las Vegas-style bet, right? That pays off equally in good times and bad times. Some contracts may matter more or less for some investors. Not every investor has the same exposure to the macroeconomy, so think about that. So anyway, these are just things to think about, not major points. Okay, overlap with investment contract and Howey. So what if you are a security under Revis but not under Howey? So you saw this in the discussion of the Securities Pacific case. Great Rivers. Capital credits. Capital credits. Ambiguous instruments like capital credits, there is a sense that we're going to prefer the Revis test and look for, in fact, some sort of bless you, debt-like application. In many cases, ambiguous contracts tend to have debt characteristics. Understand the logic here of the capital credits discussion on 328 of the casebook. It's reflecting the fact that many of these specialized contracts are like debt, and that pure equity is equity. So the simplest of all contracts is give me a residual claim to the firm's assets. So if the firm is doing well, I get paid a dividend. If the firm is doing poorly, I don't get paid. Most from that, so think of that as like a default rule, right? That's stock, that's equity. Most of these complex contracts involve giving me cash flow rights in a more sophisticated way, which means in a way that's not just tied to the financial performance of the firm, like a guaranteed payment in some cases. And that guaranteed payment in some cases makes it closer to debt. So by and large, most sort of specialized contracts for financing, at the end of the day, are all sort of hybrid of debt. Like they are moving us towards the debt world because at the end of the day, you could just buy stock if you want, buy equity stock or LP interest or you name it, if you just wanted residual cash flow exposure. But if you want to guarantee your payment in some states of the world, if you watch Shark Tank, like I recommended, and you think about these royalty deals, what are those royalty deals? What is a royalty deal? Oh, that's a good one. Yeah, we could do a royalty deal. Yeah, I'd like that. So what's a royalty deal, right? So a royalty deal is kind of like a note. It actually is a note, if you think about it. At least it's plausible coming in under Revis, right? Because you're promising to pay for every unit sold Kevin O'Leary $1, right? And that promise is like a debt contract. Kevin O'Leary will give you $100,000 for 20% of your company, and then demand $1, $2 per unit sold. That is a debt contract, that at least the royalty part, right? Because it's a promise to pay him. So it would come in under Revis, and you know now how to apply the test. Okay, loan participation rights. This is the Security Pacific case. Similarly, the application of Revis led to a dismissal of the complaint. The finding is that the loan notes were not securities. Again, there's an application of Revis. I'll just read some of this very quickly so you see how to apply Revis in case you're confused. Security Pacific was motivated by a desire to increase lines of credit. So that's fine. The plan of distribution, though, prohibited the resale to the general public. So that limited eligible buyers to those with the capacity to acquire information about the debtor. That's not good for being treated like a security, right? That's not good because that should minimize overpayment risk. That's charitably reconstructing that and kind of logically giving that a reason, right? So there's this sense that in commercial practice, you go and learn about your debtors that you're lending money to, and that takes it out of investment land. You could also rationalize that as saying overpayment risk is lower when you have the capacity yourself to acquire information. The third factor, what are the expectations? Sophisticated purchasers thought that these instruments were loans. That's very problematic. And finally, the OCC had issued guidelines concerning the sale of loan participation. That shows another regulatory scheme. So factors 2, 3, and 4 cut against a security, not a security. Okay? Everyone sees this? This is trivial stuff. Was this not in the reading? 330. I think it was in the reading. Let me double check. Opening up my syllabus here. Yeah, it was item I-1-6. One of you pointed out that I said I, and it's actually I-1. Whoever said that was very good at reading. That was very good. Yes. What was the question? Oh, we lost where we were. Okay, well, we were on page 330 of the casebook. Loan participation rights, or 329. right? Increasingly, commercial banks syndicate loans they make to corporate borrowers. They're gonna, bank's gonna lend to a corporation and then sell you the right to participate. That's the setup, okay? Apologies for going a little fast here. So, Bank of America is gonna lend to JP Morgan, Bank of America is gonna lend to Ford, and they don't wanna be on the hook for all the risk. So they're going to go find JP Morgan and Goldman Sachs and all these other companies and sell them the opportunity to participate in this loan. So give us your money and we will allow you to participate. Is that participation right in investment contract? No. No. Okay. And we went through the factors and you can reread them on page 30 and 330 and 331. More questions on this? Everyone gets it? Last but not least, swaps. A swap is a derivative where we agree to exchange cash flows. So I will pay you, I don't know, I will pay you 1/10 of the current price of the S&P 500, and you will pay me 1/10 of the current difference between the US dollar and Bitcoin. Okay, what have we done? We've kind of exchanged risk. Don't worry too much about it. You can take corporate finance to sort of really unpack that and understand how swaps work. They are derivatives. That is, their value is derived from the value of something else. In the case of a payment which is based on the value of the S&P, that is a derivative whose value to you, the cash flows from that, are derived from a security. Namely, the S&P 500 index, which itself is a derivative of all the S&P 500 stocks. So our security-based swaps, swaps like these that are based on securities. And of course, the answer is yes. It's right here. But what is a security-based swap? This is a fun topic. If you take FinReg, you can sort of dive into where all this came from. It came from the financial crisis. Security-based swap is a swap that's based on a narrow-based, non-broad-based market index. In other words, let me get the exact language, an index that is based on an index that is a narrow-based security index, or a single security or loan. In other words, the cash flows, the exchange of cash flows that are based on the S&P 500 would not constitute a security-based swap, would not be securities. Exchange of cash flows that are based on the performance of Apple or Ford, or even a small basket of stocks, like the following 5 or 10, would in fact be securities. They would be a security-based swap. Under 2A1, they are securities. No Howey test needed, or Rebus, just simple. Why is it that some swaps are not security-based swaps? That's a very long, fun conversation. Unfortunately, we don't teach commodities. Maybe one day I'll teach a commodities class for those who... By the way, fun practice area. If you like this sort of thinking, sort of very analytically and carefully, is the commodities, futures, and derivatives practice. I found that really fun because you get to deal with questions like what is a swap, what is a securities-based swap. It's sort of very, very like putting the pieces together. And that's a really fun practice area. It tends to attract nerds like myself, so not really. Okay, any other questions? Yes, Michaela. Yeah. It's a promise to pay. Yeah. It's a contract whereby I promise to pay you $1 for every unit sold. So that is a debt obligation of the firm. If you don't pay, think about it like that, the party in the other side, the counterparty, can sue you for breach of contract. So that is a debt obligation. Yeah, it's just like your lender, just like a lender. Other questions? All right, it was a marathon. Tomorrow, or more likely Thursday, we'll do the exemptions. See you then. Yes, but notes here is the courts have read note to include basically everyone's debt. So any kind of debt contract would probably be potentially reflected in this.
Yes, no, that is so sweet. I'm so jealous.
Hey, Mariah, what's up?
Your backpack is open. Like right now.
Oh, that's not a bad idea. Did AB set it up? I can ask them. It might be in short notice. All right. I might just not schedule one. We have extra hours for this class. It's 4 credits, and we're at like 3. We're at it's an hour 20 this year times 3, so we're at 4 hours. But academic hours can be have actually like 2 or 3. Might just
Well, at least it's something to like walk something to really use, so it's not. Yeah, it's great. Do we have that? I know. I doubt it. Okay, no, but I just wouldn't want to throw it away. Or we'll leave it. Yeah, I'm sure it's a little, but like if we need to cover it, I think. Okay, I think the line of that is I know. Right. Where are they coming from? Yeah, apartments. I don't know, that's all y'all. I have no idea. I was gonna throw some of this stuff down the Where should we put ours?
Just down in the front, probably. If we want food, we probably get it now, though.
Sophia, could you text Corey? Yeah.
Is he coming right now? We're waiting on him still.